On behalf of Operation Rock, my name is Clayton here with another presentation hoping to educate those who are victims of domestic violence with regard to litigation abuse, intimate partner stalking, or similar acts of domestic violence to which you are unable to defend yourself when you have an obsessed or completely determined ex-partner who is attempting to help you. So today, we are going to talk a little bit about IPS, which is intimate partner stalking. Intimate partner stalking, for those of you who don't know, is the actual act of the continued pursuit of an ex-partner who just decides not to leave you alone. Everybody, sometimes relationships end. People break up. We want things to go a certain way and they don't. Now, many times when they don't go the way we want them to, we're disappointed. Disappointment is a part of life, people. As you grow older, you realize that you're not going to get everything you want. In a perfect world, we would get everything we want, but in reality, we don't. In reality, we get the things that we work for, because I want to say this right, and we also get the things that we work for and the things that we earn, whether they're good or bad, and that's the truth. Karma is real, people. You definitely get the things that you deserve, and you definitely get the energy that you put out into the universe, and I believe that strongly. Sometimes in your life, though, you're going to run into people who are completely delusional. It doesn't matter what you do, what you say, whatever occurs. These people are going to be so obsessed with what you're doing that they're just not going to have the good common sense to leave you the hell alone when the time comes. Tonight, again, I'm going to talk a little bit about intimate partner stalking. Um, After I have this conversation about intimate partner stalking, I'm going to use some police reports and some situations from my own past experiences with a former intimate partner to show you how someone could actually use the police to continue to pursue you, bringing you into court. Now, as crazy as this might sound, audience, it is it is really common for someone to use the law in the courts to bring someone they want to see to court. Believe it or not, sometimes when someone doesn't want to be around someone and they really don't want to be, they stay the hell away from it. So some people are so crazy they realize that they have to force someone to see them. Now, what's the best way to force someone to see you without you actually kidnapping them or doing something? Is to have them mandated to appear somewhere if you can pull this off. So with most people, or at least these people who are intimate partner stalking and stalkers and those who practice the practice of litigation abuse will do, is they will start to file petitions in the family court. They'll start to file false police reports. They'll start to file paperwork that could start the process of having you brought before a court. Many times when it begins, it's for all types of reasons, people. There are 1,000 reasons people will stalk you using intimate partner stalking and vexatious litigation. Sometimes it's for love. Sometimes people love someone so much they know they can't be with them, so they'll actually use the courts and false reports just to bring this person before the court once or twice a month to physically see this person. I know this for a fact because I have an ex-girlfriend doing it to me right now. I have recently been charged in the county of New Brunswick, and I've never seen this woman. I had no contact with her. But I'm starting to realize that the reason this woman is doing this to me is because she's obsessed with me and she just needs to see me. But it's a good experience, people, because in my experience, I've learned so much that it's allowed me to empower other people. So tonight, I'm going to break down some of the key tenets of intimate partner stalking. I'm going to provide some statistics, some definitions, things of that nature. And then afterwards, like I said, we're going to walk through an intimate partner or real life situation when I show my audience, myself, Clayton Howard, how an ex-girlfriend of mine who I have an order of protection against has been using the police and the family courts to stalk and harass me for the last 3 years. I'm going to show you actual police reports. I'm going to show you actual unsealed transcripts where you see what this woman is doing, how she has been utilizing and weaponizing the law enforcement system against me in a prayer, a Hail Mary prayer, hoping to get revenge against me. The weaponization of government offices is real, people. What President Trump and Kash Patel and the rest of the government officials on Team Trump are talking about is real. The government and law enforcement official, prosecutorial offices are weaponized against people for the use of revenge or destruction by someone who can control or manipulate that office. And I've been a victim of this on a personal level at the hands of Francina Evans, an ex-girlfriend of mine on Staten Island, who has been using litigation to harass the living hell out of me. And after the end of this, I'm going to prove it tonight by showing police reports and transcripts. And I think after my description And once I show the police reports and the transcripts, anyone who watches this video will understand what litigation abuse looks like when someone uses the municipal courts and the family courts and the superior courts and the police against you to try to file cases against you to keep you before the court. Because again, people, some people are so crazy that they just need to see you. And they know that by bringing you to court, you're going to have to come to court so they get to see you. You need to know how to stay calm and structure your actions and what to do so you can stop these people who use and weaponize agencies against you. Because that's the new warfare, people. It's not fighting, it's not physical violence. It's weaponization of organizations, institutions, and people to hurt you. So you have to learn how to fight that. So without further ado, people, we're going to get right to it tonight. Let's start with our presentation on litigation abuse before we continue. Yeah, dude, we got. What the heck? Oh, it's taking too long, brother. There you go. Okay, so protecting yourself, recognizing signs of intimate partner stalking, and preventing false police report. Essential strategies for safety and awareness. Our agenda items tonight, ladies and gentlemen, are we're going to take some steps to protect yourself from stalking. We're going to examine false police reports by ex-partners. We're going to talk a little bit about vexatious litigation as a form of abuse, and we're going to try to provide some support and resources. I think I should have took that out because the truth is, people, if you're a man, there are no support and resources. That's just the truth. I got to be honest. It's depressing, but we got to face reality here. So let's start with some steps to protect yourself. Documenting evidence and keeping records. The importance of documentation. Documenting evidence in stalking situations is crucial for building a strong case if legal action is needed. What they mean by documenting evidence, people, is not just you can't document evidence, people, without actually having it organized, because organization is key. When you document, you need to keep names, dates, and chronological orders for when events actually happen. Because in being able to establish the chain of events, you'll better be able to explain to a prosecutor or a detective exactly what's going on. And at the end of this slideshow, I'm going to show everyone a conspiracy chart. As a matter of fact, you know what I'll do really quick for you guys, because this is about education. I'll show you a conspiracy chart really quick. Forgive me, ladies and gentlemen. I should have had that prepared. I don't want to waste time because people's time is valuable. So let's hurry up and get this. I just want to give you guys a visualization real quick because visualization is kind of important. Oh, that's a nice, there it is, flow chart. You need to learn how to document the details, people. So what I would suggest you do is learn how to create what's called a flow chart. A flow chart is it's a visual representation of the things that happen in a course of events. You know, if that's the best way I can explain it. So let me go there really quick for you guys. Hold on a second. I'm going to do a screen share. I think that's it. Nope, that's not it. That's not it. What the hell? Am I messing up today? That is it. I'm sorry. There it goes. All right. Okay, there we go. That's it, people. All right. Without further ado, a conspiracy flow chart. Here we go, ladies and gentlemen. This is a conspiracy flow chart. As you can see, this is my conspiracy flow chart, and it details what happened with myself and my ex-girlfriend, Francina Evans. So in documenting evidence, everyone, oh my God, come on, big screen. Why are you playing with us today? Okay, so in documenting evidence, everyone, I can't seem to move. It's not showing me that much love today. All right, bet. As you can see here, people, I show you where it started. It started with the Newark police, blah, blah, blah. Essex family court, etc. You want to keep events consistent because you need to be able to show the picture when the time comes to reveal your evidence. So documentation is incredibly important, ladies and gentlemen. Let's X out of that one. Let's stop the screen share and let's go back to the presentation. Oh, sorry. Hold on a second. We're having one of those days, people. Some technical difficulties. Back here. There we go. All right. So I think we were at 3. Yes. Okay. Detailed record keeping. Keep a record of the incidents with essential details such as dates, times, and location to support your claim. Legal preparedness. Proper documentation can prove vital should you need to pursue legal action, emphasizing the need for thorough records. Now, people, here's the truth. With false reporting and vexatious litigation, the police do not arrest people for filing false reports. They do not arrest people for filing false petitions in family court. They will never do that, people. They will never arrest someone for filing a false report. It actually has nothing to do with racism, people. This is how much I've grown. I've learned that. It has everything to do with the fact that the cops won't arrest people for filing false reports because it really hurts them. The police know that a lot of the reports that they file are false, ladies and gentlemen. They know it. But those reports are used to substantiate the entire system or the framework of the police activity within a certain jurisdiction. So now, if the police start charging people who file false reports, you have to realize something, that other people would stop filing false reports, which would kind of mean reports would go down, or in essence, crime might drop. The police don't want that. So what the police are going to do is allow anyone to file a complaint, because basically they can pick and choose who they want to fuck with and who they don't want to fuck with. And I can say this again because I'm an unfortunate minority who this was done to, because I had a pretty ex for 3 years in several places. Let's see, seeking help and from support networks. Emotional support. Reaching out to friends and family can provide vital emotional support during challenging times. Sharing your experiences with others can help reduce the feelings of isolation and foster connection. But you also have to be careful about that, because many times if you have a calculating and capable offender, they may send people at you to garner information. So now you're just looking for support and sharing information with you, but you may have a bunch of spies around you just trying to get information or set you up for your offender. So this is actually something that I provide as advice, but I also advise you to be careful on who you share information with. Everyone is not deserving of trust. Many people will betray you, especially if you happen to be someone with an offender who can garner people to like them. You will be betrayed. You can almost guarantee it. So I want to advise everyone, though, that even though it's good to get it off your chest and not hold it in, you'll need to. You'll need to do that just to be able to function and have the mentality to fight back and not lose your mind. But be careful about who you share the information with, because those same people could be spies for your offender and hurt you. Developing a safety plan. Support networks can assist in creating a safety plan tailored to your needs and circumstances, which is true, people. If something happens, you can holler at somebody like, yo, people's at my house. Can I stay here tonight? And having friends and family is important to go do that if you need to get away. Legal measures and restraining orders. Oh God, people, restraining orders. I don't have much to say at this moment about restraining orders. Protection from abuse. Legal measures like restraining orders are essential for providing protection from abusive partners and ensuring victim safety. Understanding legal processes. Understanding the legal process and requirements for obtaining a restraining order can empower victims to seek help. Empowerment through knowledge. Knowledge about legal rights and options can empower victims to take necessary actions against abuse and seek justice. Now, people, I 100% agree with all of these. Even the order of protection, now that I think about it a little further, because here's the truth, people. You need the order of protection, at least to have a document that says, something, you need a final order of protection. The temporary order of protection is based on allegations that are unproven. You need a final order of protection that has been decided by a judge, so you can verify definitively that the word of a judge who is trained in matters of domestic violence is the one who provided you with a decision that says your rights, or that your domestic violence or your personal rights, were violated. The order might not be enforced. Law enforcement is funny, people. They want to protect the people they want to protect. They want to arrest the people they want to arrest. And many times in those situations, if you're a black man or a minority man and you happen to have an order of protection, I'm going to be honest, if you're a man in general, let me not shit on my white brothers. My white brothers out there, y'all victims of this story too. So I'm sorry for denying you guys the rights and the privileges that you deserve. Because white men are horribly treated in domestic violence cases also. And I really need to say that from things I've learned in the last couple of months. But the restraining order is necessary, because the restraining order even tells police, even if they choose not to listen, that a decision was made regarding your rights and your protection, the protections awarded to you as a victim. And it also acts as a basis if the police don't choose to help you or you're maliciously prosecuted or arrested. It further supports your claim against that malicious prosecution if you happen to have an order of protection that the police are ignoring. So that's key. So I recommend to anyone with valid allegations, that's key. Don't make up stuff to get an order of protection, because people what don't come out in the rinse, what don't come out in the wash, damn sure comes out in the rinse. If you lie on somebody in a petition and think you're going to get away with it, remember, you got to go to trial. You don't know the capabilities of the person you're dealing with. And if they figure out and calm down enough to prove you to be a liar, you got a problem. So don't lie on anybody on a family court petition. You tell the truth. You allege things that are actual. You don't manipulate evidence. You provide all the testimony. If there's a text string, you provide that entire text string. You don't provide pieces. Because if you provide pieces and the person you're against can provide the whole conversation that proves you're lying, you got a problem. So I advocate for the truth, ladies and gentlemen. I recommend that you tell the truth and you provide all the evidence, not pieces. You must understand the legal process. Again, people, if you've been watching my broadcast for the last couple of months, you have noticed the transformation within me. I respect the legal process. I know how it goes. I hate it. I think it sucks. But there is an order to the way things goes. You have to have a first appearance. You have to have discovery. You have to have conferences. You have to have a trial. After a trial, you got an appeal. You have to learn the process and the procedure in whatever you do with regard to any industry or field you deal with in your life. And civil rights or family law or criminal law is one of those fields. So if you get yourself in one of these situations where you feel you need an order of protection, it's best to understand how an order of protection works, what you have to do to file it, what you have to do if you need to amend it, and what you need to do if you need to enforce it. And believe me, people, from someone who has multiple orders of protection against my ex, I wish that someone had given me this information in the beginning. Because I've had order of protections for 3 years, people, and I didn't know what to do with them up until recently, people. I know what to do, and hopefully, someone needs help again, people. You can easily DM me. I'll give you some assistance, some paperwork. I'll show you what to do if law enforcement is trying to shit on you, people, because you can do something. False reports by ex-partners. That's a big one, people. Understanding false reporting and its impact. Undermining legitimate claims. False reporting can distort the truth, affecting genuine cases and undermining the credibility of victims. Wrongful accusation. False reports can lead to severe consequences, including wrongful accusations and damage to innocent lives. Burden on law enforcement. Handling false reports consumes resources that can divert attention from legitimate cases, straining law enforcement efforts. And everyone, that's true. You have thousands of women who are abused physically every day. Every day, women are abused. Imagine how a woman who abused would feel. I would say a woman who is abused should feel anger at any woman who uses the police to lie and say she was physically abused, because that 5 minute that woman who's really being abused was getting beat, smacked, just totally disrespected, they probably was wasting 3 of those minutes with the woman who was lying to the police. Women and people who lie to the police divert time from the work that police are actually supposed to do, which is protect real victims who are really being violated. Because someone feels that they've been hurt emotionally by someone, they don't have the right to use the police to seek revenge on them, because they can't physically do anything to the person. Yet this is what happens a lot, especially in domestic violence, with ex-partners who want someone back and know they have no chance of getting it. So what they decide to do is do things like this in an attempt to keep the person in their life, because they really can't let go. So what they'll do is they'll use vexatious litigation, lies to the police, false litigation, just to keep this person in their life consistently so it keeps going. Statistics on false reporting. Impact of false reports. False reports can prove profound effects on the lives of the accused, leading to reputational damage and emotional distress. The credibility of real victims. The existence of false reports can undermine the credibility of genuine victims, making it harder for them to be believed. The importance of awareness. Raising awareness about the statistics of false reporting is essential to prevent harm to the innocent individuals and support true victims. Now, people, this is truth. When someone continuously files false reports on what they're doing is they're trying to build their own case that they can use against you collectively at some point to establish a claim, a larger claim of harassment. That's just the basic premise of someone who files multiple false reports on you. Now, the problem with that is if you're in a situation where you go to multiple law enforcement agencies with the truth and based off gender bias, racism, personal favoritism, all of those things that law enforcement, like cops and prosecutors, are not supposed to do but do all the time. If you have to deal with that in 4 or 5 counties, you have to realize something. Your offender has now created 4 or 5 different counties where prosecutors have totally crapped on. So if she's able to get, let's say, or he is able to, let's say, and I'm in the state of New Jersey, so let's say they can get a civilian complaint on you for a public disturbance or a disorderly persons offense, because that's what the municipal courts in New Jersey offer: disorderly persons offense. 3 or 4 disorderly personal offenses with the right lie is enough to get you convicted of something in a felony court. This is the pattern of litigation abuse imposed on victims by offenders who choose to use this course of action to continue to keep themselves and someone's life and create further harm. Maintain clear communicate. Oh, steps to protect yourself from false accusations. Maintain clear communication to reduce misunderstandings. Ensure that all communication is clear, concise, and documented whenever possible. People, that's key. And I totally believe that. When I go to the precinct, yo, you got a body cam, cut that shit off. I go to the court, yo, the transcriber is here, right? We're not going, the judges in here. Oh, where's the record of the court? Are we recording this? We need to record this because everything that was said needs to be able to be referenced. People, I no longer play with going to meetings and recording people. And the reason I do that is because I have discovered something that it takes you to become a man to realize that people will lie to you to your face and change it the second they get away from you. Now, you may not, and this has happened to everybody. I can't even say that you may not understand this. Everyone knows, everyone has had a situation in their life where someone has told them one thing and then completely changed it when they were called to account for what they said. The problem with that is if you don't have a record that someone said anything to you, then it becomes your word against theirs. So the best thing you can do is record every word in every encounter you have with anybody who's involved in this situation. Now, the one thing you have to do is you have to check the laws governing audio recordings and recording people within your state, because every state is not what's known as a one-party state. A one-party state is a state that you can record as long as you consent. It doesn't matter if the other person consents or not. You don't even have to tell them. The only thing you have to do is be aware you're recording and why you're recording, and that justifies as your consent, so you can record them on the phone. Now, however, if they start the conversation and they say, I don't want to be recorded, then you are not supposed to record them. You're supposed to tell them, you're supposed to instruct them that you want to record. And if they insist on not being recorded and hang up the call, then that's it. But if you just decide to record someone and present the recording in court, people, that's not illegal, at least in my state, in the state of New Jersey. So you need to familiarize yourself with the rules of evidence and your local rules regarding documenting the audio conversation between you and another person. Document interactions. Keeping records of your interactions can provide evidence and support your case if needed in the future, which is what I just said. Seek legal counsel. If you feel threatened by potential accusations, consult with a legal professional to understand your rights and options. Know your rights. Being informed about your rights can empower you and provide peace of mind when facing. Hold on a second. I'm sorry. I just got a message. When facing. What the hell is my chat? Okay. All right. Hey, how you doing? All right. Can provide peace of mind when facing accusations. Now, here's the truth, ladies and gentlemen. Seeking legal counsel is what you should do because lawyers are trained to handle the judicial process, whether it be criminal, civil, or family. A lawyer's job is to handle the process. They go to school to be trained. So you have to respect the profession, even though what I'm about to say is a 100% truth, that the majority of lawyers on the lower level are complete pieces of shit. And that's just the truth, people, especially if you're involved in domestic violence and family court. Unless you have money to deal with this, it's very rare that you will run into an honest attorney with the integrity to do the right thing and get what you exactly need done. It's very rare that you will get that actual representation that you need. Because if you have what's called the public pretender, which is what I like to call them, their only mission truly is to support the court so they can keep billing the state and make money. So whether or not your rights are being violated procedurally, statutory, anything, a pro bono lawyer, a lawyer assigned to you by the family court or the criminal court, doesn't care if your procedural rights are violated. They don't want to challenge the institution that's paying them. and this is an exact truth. What they would do is withhold the procedural violation. They'll try to get you off still. I wouldn't say all of them are set up because they're going to do their due diligence. They're going to try to get you off, but you're going to get a lackluster performance that's not even worthy of them calling you themselves attorneys. So you need to be prepared for that. The best thing you can do to be prepared for that is familiarize yourself with your situation, what you've been charged with, what you intend to charge someone else with, and then you try to learn the procedures, the requirements, and the provisions of what you intend to do or what this person's do so you can effectively fight them. That's the best thing you can do instead of relying on an attorney. If you can learn enough about your rights to work with an attorney, you got a shot. I'm not going to say you got a good shot, but you got a shot to get out of it. Without that, people, ignorance is not bliss, especially in this situation. Ignorance is not bliss in matters of family justice, criminal justice, or civil justice. If you are dumb, you are going to lose. That's a fact. They're going to keep you in the dark. No one's going to tell you what's going on, and I can tell you this because I've lived it for the last year of my life. Up until the point where I opened the book, I was constantly lied to. The second I gained the knowledge to converse back with these people, guess what? They couldn't lie anymore. And now there's a certain level of respect. Of course, they still don't respect me because I'm an African American male with a past criminal history. But they have to respect the knowledge that I can spew because even if I was dumb, I seem to be able to relay some things well enough that they don't want to play games. And people, I suggest that for all of you. Definitely educate yourself with regard to your rights and procedure. Vexatious litigation as a form of abuse. Definitions and examples of vexatious litigation. Understanding vexatious litigation. Vexatious litigation refers to legal actions taken without sufficient grounds, often to harass or burden the opposing party. Purpose of vexatious lawsuits. These lawsuits are often filed to exhaust the resources and patience of the other party rather than to seek legitimate legal remedy, Examples of vexatious litigation. Common examples include repetitive filings over minor issues designed to create stress and distraction for the defendant. Totally true, people. How it is used as a financial and emotional warfare tool. Financial strain and tactics. Litigation tactics often aim to create significant financial pressure on the victim, forcing them to settle for less, or and hire attorneys, people, because you got to hire attorneys if you're being civilly sued. You got to settle if that's the case. If you're being criminally prosecuted and you might not have a record, you got to take a plea deal. It's a nightmare. Emotional distress. These tactics can also inflict emotional distress, making it difficult for victims to manage their legal cases effectively. Influencing legal outcomes. Victims may feel compelled to withdraw from legitimate legal matters due to overwhelming pressure impacting justice. People, I can relate to that, people, because man, I've thought of giving up a bunch of times because these racist law and biased law enforcement officials choose not to prosecute my offender. I have thought of giving up 1,000 times. I just know I can't because my offender won't give up. See, people, I can't stop this because my offender won't stop. And I've tried to stop. So the best thing I've learned to do, people, is stay strong and fight. You have to fight if your offender won't stop because you thinking that if you stop, they stop, you fucking wrong. They're not going to stop. Their whole mission is to destroy you. So you stop and you just letting them continue further in the race to get ahead of you. You have to stop them. And you don't have to use violence. They want you to use violence because using violence gives them the ground to turn back to the very same law enforcement that may not help you. You have to figure out how to do this to stop them. Legal resources and strategies to combat vexatious litigation. Protective orders, as we said, victims of vexatious litigation can seek protective orders to safeguard themselves from further harassment and harm. Motions to dismiss. Filing motions to dismiss frivolous lawsuits is a crucial strategy for victims to combat vexatious litigation effectively. Consult legal professionals. As you know, people, consulting a lawyer will definitely help. But again, I definitely advise you to learn the statutes or whatever it is that you are doing, at least basically enough that when you consult this attorney, you know what's going on, people, because that's key. Resources and support. Organizations and hotlines for victims. People, I kind of tried to do some research for this, but I found the most generic places. In New York, I found Safe Horizon. I've dealt with these agencies, Safe Horizon, the Family Justice Center. People, those agencies are full of shit. They're con artists. They create victims. They falsify documents. I would never recommend the Family Justice Center of New York or Safe Horizon to anyone. I will never recommend the Essex County Prosecutor's Office victim witness to any legitimate victim. People, these organizations are only about money and publicity. If you're a victim, the best thing resource you have is a library. Trust me. That's the only resource I advise everybody to get. You get a damn library and you dedicate yourself to as much education with regard to what's happening to you as possible. The only resource you need is knowledge. Calling someone begging for help, the only thing they want to do is put you in a shelter, put you in a program, or try to compensate you for something by using a victim services fund that might have been established by whatever state you're in. They're not going to advocate for you with prosecutors. They're not going to do that. The entire victim witness creation is a complete lie. They help who they choose to help. They do not help the real victims. And I swear to that. Legal aid and support services, assistance for victim. Legal aid does not help people. If you have a criminal case, legal aid represents you. But one thing you have to realize about these free services is that these attorneys and these advocates are overloaded. They're overloaded. There's no way you can put 100% of everything of yourself into everything. You can't. It's impossible. You have to fragment yourself amongst all of your activities so everything gets a piece of you. So if you're dealing with an attorney who has 100 cases, how much of their time do you really think you're getting, people? If they're a one-person firm, you're not getting a lot of time per week that you can actually say my case is progressing. And the problem is if you have a case, your case should always be progressing. The evidence should always be examined. Your attorney should know at all times what's going on in your legal matter. The problem is if you have an attorney who's so overloaded they can't know that, then how can you properly be represented? You can't. Building a safety plan and ongoing protection. I don't want to read that, people. Oh, you know what? Some of these some women do watch my broadcast, but people, I just have a firm belief that law enforcement will never protect you, people. Law enforcement is corrupt. Um, I can't say I myself have been encountered 8 separate police departments. I can't say I've ever run into one where they were just. They're biased. There's incredible gender bias. Most of the time, if you're in an area where there happens to not be a large minority class, there's some racism issues you have to deal with. It's real, people. You definitely have to have a strong network of people you can trust and rely on. So, should a situation or an emergency come, you have an avenue or an outlet for escape. I do not recommend the police because the police only protect those who they want to protect. I recommend strong friends and family that you know that love you enough that will hold you down when you need it, people, because that's all you can really count on in the end is the people who love you. And necessarily that might not be blood family, people. Family is more than blood. Family are the people who support you regardless of whatever the hell goes on with you or whatever you do. They love you enough to be there for you. So if you got somebody like that, you tell them about what's going on and you create a way to communicate with them. So should you need that support, they're there for you. Statistics on intimate partner stalking. According to the National Intimate Partner and Sexual Violence Survey, NISVS, approximately 1 in 6 women and 1 in 17 men have experienced stalking at some point in their life. Damn, people, y'all being taught by a diamond in the rough. I'm 1 in 17. According to 60 to 75% of stalking victims, around 60 to 75% of stalking victims are stalked by a current or former partner. Totally true. The average duration of intimate partner stalking varies, but typically lasts between 6 months and 2 years. However, some cases have been documented lasting over a decade, particularly when legal or protective measures fail. I can relate to that, people. I'm going on 4 years. Victims of intimate partner stalking are more likely to experience severe violence, with 81% of women stalked by an intimate partner reporting they were also physically abused. Now, actually, intimate partner stalking, as you can see, is much more common in women than men because guys are possessive people. Most of the time, a relationship with a man and a woman is one of submission. A woman gives her body to a man, she allows him to enter her. So that's a form of possession to a man who thinks he owns a woman. So when that woman denies him the fruits of her loins, she denies him her personal pleasures, and he's used to being able to call on that at will. Of course, he's going to be like something like, oh, she's mine, start following her. He's going to start to feel that the next man dating her is violating him. That's my woman. We hear about it all the time, people. We have to deal with stalking with regard to just, I want to say, physical contact. The best way to deal with that, unfortunately, is the police. But now here's the thing. If you're a woman, you're okay with that, because if you're being stalked as a woman, most of the time, I would say 90 to 95% of the time, the police are going to help you. Vexatious litigation as a tool for continued harm. One of the more insidious methods used in intimate partner offenders to continue their control and harassment is vexatious litigation. This involves the abuser misusing the legal system to harass, intimidate, or financially drain the victim. Some common tactics include filing frivolous lawsuits, defamation, custody battles, or small claims actions, repeated petitions for modification of custody or restraining orders, baseless criminal complaints to entangle the victim in the justice system, subpoenaing victims to court proceedings as a means to force contact. Courts often struggle to recognize this as an extension of abuse, prolonging the victim's distress and sometimes forcing ongoing interaction with their stalker. Now, people, as sad as it is to say, I can definitely attest to this. And at the end of this presentation in 3 slides, I'm going to show you police reports and family court petitions where exactly what this says has happened to me. And my ex-girlfriend has done this to me. And you'll see what intimate partner stalking looks like when someone uses litigation just to bring you before the court so they can see you. Escalation of danger over time. The longer intimate partner stalking persists, the greater the likelihood of severe consequences, including physical harm or homicide. Below are key points illustrating how extended stalking increases risk. The early stages of intimate partner stalking, between 0 and 6 months, the invader engages in non-threatening behaviors such as excessive calls, texts, and social media monitoring. Next is the intermediate stages of intimate partner stalking, which is usually between 6 to 12 months and 12 months, escalation to threats, property damage, and surveillance. Advanced stages of 1 to plus years include increased risk of physical assault or homicide, particularly when victims attempt to leave or enforce protective orders. Intimate partner stalking is a severe and persistent threat to victims, often lasting years and escalating to physical violence. The misuse of the legal system through vexatious litigation only prolongs the suffering of victims. Proper legal reforms, better enforcement of protective orders, and increased awareness are necessary to prevent the prolonged victimization and mitigate the risks associated with long-term stalking behaviors. In conclusion, understanding the signs of litigation abuse and intimate partner stalking, um, recognizing the signs of stalking and false accusations is crucial for your protection and safety. Taking protective steps can enhance your safety and reduce the risk of being targeted. And accessing available resources and support systems can empower you to handle the situation effectively. Now, ladies and gentlemen, here's the problem. We have a situation, and I have to get out of this screen. Presentation is off. 1 second. Let's cut the presentation off, ladies and gentlemen. Here we go. Cut the presentation off. You know what? Let's try it like this. I'm sorry, I can't figure out how to cut the damn presentation off, people. There we go. Okay. So, ladies and gentlemen, that's just a brief broad slideshow on what intimate partner stalking is, how it affects people. Um, there's really not a whole lot that I can say. It's a slippery slope, people. It's not one of those things that you can give someone a definitive course of action when it comes to them being stalked by someone who uses litigation. It's actually really complex, people. It's probably one of the hardest things you will have to prove to anyone who you seek to get help from, is proving the pattern of the events that continue to go on. Like I said myself, I've been a victim of intimate partner stalking and vexatious litigation for about 3.5, 4 years now. Dated this girl. Girl is completely obsessed. She's crazy as hell. She decides, you know what? I want to put this guy in jail because he doesn't want me. And guess what, people? I get arrested for this. Now, what I want to show my audience is I'm going to go to the screen. Let's do a screen share. Okay, I hope everyone can see my screen. So this basically was myself sending myself an email. I'm going to show you guys all some stuff to verify what has unfortunately taken place in my life. So again, my ex-girlfriend was charged on May 19th with May 8th in offenses in Newark, New Jersey. In response to that, she went to Staten Island and she filed this protective order against me, accusing me of multiple acts of domestic violence. As you can see, she said I was guilty of harassment in the first and second degree, aggravated harassment in the second, assault in the second and third degree, criminal mischief. I strangled her. I stole her identity in the first, second, and third degree. That I coerced her in the second degree. That I was menacing her in the second and third degree. That I was that I had engaged in reckless endangerment. That I was stalking her. That I had attempted to assault her. That I forcibly touched her. That I had tried to choke her out. I guess that's what criminal obstruction of breathing and circulation is. That I stole from her, and that I unlawfully possessed intimate images of her. So this is the petition that she verified to be true and exact before the Family Court of New York. Now the problem with that, ladies and gentlemen, is this. On 11/17 of 2023, there we go. I thought we wasn't on. On 11/17 of 2023, this woman was put on the stand before the Family Court of New York. And before the Family Court of New York, she was cross-examined by my attorney. Before you, what you see is that cross-examination where this woman actually denies filing the petition that I just showed you. The reason she denied it is because I was able to prove that I had never committed any act of physical domestic violence against her. So, not wanting to be perjured or being impeached, her credibility being impeached and being proven to be a liar, what she decided to do was deny the fact that she even created this petition. So, as you can see, the question asked to my ex girlfriend is I asked that you review the document, which is the order of protection that has been marked as Respondent's Exhibit A, and let me know when you are finished. Okay, yes, so I just asked if you were finished. Yes or no? I have finished reviewing the petition once again. Is that your position that you approve for the Family Justice Center to submit to the court? Yes or no? That is not the petition. No. Thank you. So, this woman denies filing the petition that has had me arrested multiple times based on filing false allegations of physical domestic violence before the Family Court of New York. Um, I've done everything to stop her, people. She just keeps coming after me because she's obsessed with me. After I win this order of protection, let me see it right here, people. Da 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 da. Well, I actually don't have it. So people, there are just 1,000 police reports. I actually was gonna show some more of these people, but I don't even want to. I'm kind of so over this, people. I don't want to waste my energy. But as you can see, people, here's some more complaints here. These are two complaints that she filed against me in the borough of Carteret, New Jersey. So as you can see, I've been charged in Carteret, New Jersey. Here you go. Carteret, the Carteret Municipal Court. I have been charged in Newark. Here you go. That's from Internal Affairs for me investigating Newark because my ex claimed that I reported her falsely for child abuse. What you see before you is a report from Newark's Internal Affairs that verifies that I never had this woman investigated for child abuse. But this woman continued to accuse me falsely of doing something that the Newark police have 100% verified I never did. This woman has had me charged in New York, and people I have there. This is one police borough. Remember that, people. These are the ones that were actually taking action on. The truth is, between Essex County, New Jersey, Carteret, New Jersey, New Brunswick, and Staten Island, New York, 57 police reports have been filed against me in the last 5 years. That's 5-7 by Francina Evans, my insane ex-girlfriend who continues to stalk me. Uh, 57 reports, ladies and gentlemen. So before you now, you see the decision of trial of Family Court Justice Amy Manikin. This is public record. Anyone who chooses to look this up will know it is not under seal. You will know what this says. So this is a motion that Francina Evans, my ex, filed against me because remember, part of the tactics of litigation is abuse is to continue to take the person to court to try to get amendments, try to get dismissals, to just continually make new allegations so you can keep bringing this person to court. So what I want to do is I want to read this decision for the public because it's going to provide you this procedural history of what's been happening with myself and the person who's been using vexatious litigation against me. So the matter before the court by way of motion for reconsideration uh, filed by the defendant. And as you can see here, the defendant was Francina Evans, my ex. Um, seeking a reconsideration of the court's decision denying her motion to dismiss the final restraining order on February 16. Defendant's motion for reconsideration was filed on March 6, 2024. This opinion follows as the court's decision on the defendant's motion for reconsideration. Procedural history. The court must address the relevant procedural history of this matter. The court notes that the parties have been in an extensive history of litigation. On June 22nd of 2022, the plaintiff, Mr. Howard, obtained a temporary restraining order against defendant Evans. On July 8th, Ms. Evans obtained a TRO against Mr. Howard. The trial for the instant matter of the order of protection FV073579-22 and the counter restraining order FV0700018223 took place over the course of multiple days with both parties present on October 6th, October 27th, October 28th, and December 1st. Judge Sanders entered the FRO against Ms. Evans on the grounds of harassment and burglary and dismissed the TRO against Mr. Howard. On October 13th of 2023, the defendant filed a motion to dismiss the FRO, Carfagno motion. The hearing on the defendant's motion was initially scheduled for November 16th of 2023. The plaintiff requested additional time to retain counsel, and the court adjourned to a hearing on December 20th. On December 20th, the court held the first hearing on the defendant's Carfagno motion, and both parties and the plaintiff's then attorney present in courtroom. The defendant did not have the trial transcript ready for the court and requested additional time to obtain the transcript. With a fee waiver, the court granted this request and ordered the defendant to submit a written trial transcript and evidence by July 25th of 2024, and ordered the plaintiff to submit his response to a motion by February 8th. The defendant did not submit the trial transcript as directed and instead submitted CD recordings of the trial. On July 18th of 2024, the plaintiff counsel filed a motion to be relieved as counsel was granted by the court. Now, I was the plaintiff, everyone, so I fired my lawyer on July 18th of 2024, and I took the case over myself. That is the court documenting that I, the plaintiff, which will go back to the top. As you can see, Clayton Howard's the plaintiff, Francina Evans is the defendant. I fired my lawyer on January 18th of 2024 because I began to realize I could do a better job than him. On February 1st, 2024, the plaintiff filed a cross motion requesting a mental health evaluation for the defendant, compensatory and punitive damages, and an order from the court prohibiting the defendant from posting about him on social media. On February 16, 2024, the court held a second hearing on the defendant's Carfagno motion, and the plaintiff cross motion with both parties and the defendant's then attorney present. The court denied both the defendant's motion and the plaintiff's cross motion for reasons that were stated on the record. Can't show you the transcript, but basically what happened, people, is the judge denied me because she said I didn't file the paperwork right. She, on the record, she stated Francina Evans was a pathological liar who had been stalking me between the states of New York and New Jersey for years. And she ordered Francina Evans to leave me alone. That was pretty much the way the decision went. As you see, she denied it, so my order of protection was valid. Let me see. On March 6th, the defendant filed a motion for reconsideration of her Carfagno motion, and the hearing on this motion was originally scheduled for May 16th of 2024. On March 21st of 2024, the plaintiff filed a motion for reconsideration of his January 1st, 2024 motion. The court held a hearing on the motion on April 30th, where the plaintiff appeared in person and the defendant did not appear. The plaintiff motions were denied for reasons on the record. People, again, they told me I filled out the paperwork wrong. Not that I was lying, that I filled out the paperwork wrong, and there was a certain thing the way I had to fill it out if I wanted the reimbursement for what my ex was doing to me. So people, they basically fucked me and lied, which is what the family court does. On June 4th of 2024, the court held a virtual hearing on the defendant's motion for reconsideration with both parties and the defendant current and attorney present. Conclusions of laws. Now, this is the decision of law. The defendant filed a motion for reconsideration of her motion to dismiss the FRO on March 6, 2024. The court will set forth the legal standard and basis for both the motion and the reconsideration and the underlying Carfagno motion that was denied on February 16th of 2024. 1. Motion for reconsideration. A. Legal standard. Rule 449-2 permits a party to petition a court for reconsideration of an order. See State versus Wilson, 442, New Jersey Superior Court, 224, 233, Appellate Division, 2015. Certified, granted, whatever. Although motions for reconsiderations are not expressly provided by Part 3 of the Rules of Court, governing practice in criminal courts, we have nonetheless applied the standards contained in Rule 449-2 to such applications. Da, 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 da. I don't think we need to read that. That's just too much. Y'all need that. Y'all need the analysis. The court has considered the application of the moving party in this motion for the reconsideration. Reconsideration motions should not be used merely because a dissatisfaction with the court's decision. A motion for reconsideration is designed to review an order based on the evidence initially before the court, not to serve as a vehicle to introduce new evidence in an order or to cure an inadequacy of the record. The motion must state with specificity the basis upon which it is made and must include a statement of the matters of or controlling decisions that the movement believes the court overlooked or as to which it erred. In this matter, the defender filed a motion for reconsideration of her motion to dismiss the FRO on October 13th of 2023. The underlying Carfagno motion was denied by the court on February 16th upon review of the submissions of both parties and two hearings on the matter. In order to grant the defendant's motion, the court would have to persuade that its prior findings were clearly mistaken. Oh, okay. In order to grant the defendant's motion, the court would have to be persuaded that its prior findings were clearly mistaken, otherwise not supported by adequate, substantial, credible evidence. As support for this motion, the defendant submits a repetition of allegations raised in the previous motion. A hearing was held on the motion for reconsideration on June 4th, 2024. The court finds that the defendant did not sufficiently demonstrate with specificity any evidence overlooked by the court or how the court erred in denying the Carfagno motion. Therefore, the motion for reconsideration is denied. Basically, what the court says is there is no new evidence. We denied you because it was proven that you lied the first time, and you didn't show us that it wasn't a lie the first time, so we're not going to grant it to you the second time. Legal standard for dismissing a final restraining order. To secure a final restraining order, the FRO, under the Prevention of Domestic Violence Act, a plaintiff must establish that the defendant committed a predicate act of domestic violence as defined by New Jersey statutes anointed 2C 2519A, and that restraining order is required to protect the victim from further acts of domestic violence. The predicate acts of New Jersey statute, the Prevention of Domestic Violence Act, I'll just say it shortly, include harassment and burglary, upon which the FRO in this matter is based. The PDVA, the Prevention of Domestic Violence Act, is designed to assure victims of domestic violence the maximum protection from abuse the law can provide. The Supreme Court held that its core, the 1991 Act, effectuate the notion that the victim of domestic violence is entitled to be left alone, which is in essence the basic protection the law seeks to assure the victim. So as you can see here, the judge is explaining to my ex that the primary focus of the order of protection is to grant me the right to be left alone, something that I can show you she has never done because law enforcement will not charge her with harassing the living shit out of me. However, the legislature did not intend for every final restraining order issued pursuant to PDVA be forever etched in judicial stone. The PDVA allows the trial court to dissolve or modify an FRO upon good cause. Generally, a court may dissolve an injunction where there is a change in circumstances whereby the continued enforcement of the injunctive process would be inequitable, oppressive, or unjust, or in contravention of the police of law. Only where the movement demonstrates substantial changes in the circumstance that exists at the time of the final hearing should the court entertain the application for dismissal. With protection of the victim, the primary objective, the court must carefully scrutinize the record and carefully consider the totality of the circumstances before removing the protective shield. New Jersey, the Prevention of Domestic Violence Act provides that an FRO may be dissolved or modified upon the application only if the judge who dissolves or modifies the order is the same judge who entered the order or has available a competent record of the hearing or hearings on which the order was based, emphasis added. At the minimum, all pleadings and orders the court filed and a complete transcript of the final restraining order. Failure to obtain the transcript will be fatal to the application, as the removing court will be unable to determine which the circumstances exist at the time of the FRO substantially changed. Here, the defendant did not submit the written trial strategy as instructed, despite having been granted ample additional time to do so. Instead, she submitted CD recordings of the trial, which could not be accessed by the court. The court therefore relied on court smart recordings to review the full record. And I provided the transcript, people, because I actually paid for them to provide them to the court to show the court what actually happened during the trial, that my ex was lying. Analysis of the Carfagno motions. Actually, I only want to get to one part of this, whether the victim consents. Regarding this factor, first factor, this is important, people, because in order to get this motion dismissed in New Jersey, I had to consent to the order being dismissed. Now, listen to what the court says with regard to my action against my ex. Whether the victim consented to lift the restraining order. According to this first factor, the Carfagno court states that the legislator intended that the court should allow the victim's request to dissolve a domestic violence order or to dismiss the domestic violence complaint without further legal analysis. When construing a statute, the court must follow the legislative intent considering the policy undermining the statute. Here, the plaintiff, myself, is vehemently opposed to the dissolution of the restraining order. Therefore, the court finds that this factor weighs strongly against the defendant's application to dismiss the FRO, whether the victim fears the defendant. As the second factor, the Carfagno court stated, the act protects victims from physical harm, yet physical safety is not all that the legislator intended to protect. Recognizing that domestic violence occurs in a relationship where one party asserts power over control over the other, the victim is also protected from mental and emotional harm. Fear of the defendant is the center of the cycle of power and controlling existence of domestic violence situation. Restraining orders have the effect of empowering victims to stand up against to the defendant. Thus, fear is important to consider. Here's the court's response to whether or not I have a legal claim to be afraid of my ex. Here, the plaintiff asserts that he remains in serious fear of the defendant. This court notes that the plaintiff does not allege fear of physical harm by the defendant. Rather, he testified that the defendant's acts of harassment and the resultant impact on his mental and emotional health have caused him to legitimately fear the defendant. Now, per the Carfagno court analysis, the question remains whether the court should focus on substantive fear or objective fear. Subjective fear, is the fear produced by and within the mind of the victim as the victim understands and communicates it. Objective fear is that which a reasonable victim similarly situated would have under the circumstances. The court holds that the courts should focus on objective fear. The legislative intends the court to consider objective, not subjective fear. Now, the court finds that a reasonable victim similarly situated as myself would be fearful of my ex Francina Evans. The previous history of domestic violence between the parties must fully be explored and considered to understand the totality of the circumstances of the relationship and to fully evaluate the reasonableness of the victim's continued fear of his perpetrator, myself. Here, the FRO was entered less than 2 years ago. The parties have an extensive history of past and ongoing litigation in the family and criminal courts across New York and New Jersey and form a reasonable basis for the plaintiff's continued fear. The defendant asserts that the plaintiff is not afraid of her. She argues that the plaintiff's numerous aggressive communications to her and about her on social media demonstrate a lack of fear. Rather, she argues they demonstrate acts of harassment towards her. This is important, people. The court notes that the plaintiff has in fact posted frequently about the defendant online and across social media platforms, posting photos about the defendant and pleading her to stop harassing him through false litigation and abusive litigation. First, the court notes that these communications by the plaintiff do not violate the restraining order he has against the defendant. Next, the court notes that the posts are protected by the First Amendment. There is no harassment exception to free speech. State versus Burkett, that's the case. Moreover, the Superior Court has held that even speech encouraging unlawful acts is protected unless it aims to incite imminent lawless action is as likely to achieve it. This court does not encourage such communication or posting by the defendant by the plaintiff, myself, about the defendant. However, based on the facts and the relevant case law, the court does not find that these postings are unlawful and that they negate the fear the plaintiff has of the defendant. Therefore, the court finds that the fear weighs against the defendant's application to dismiss the FRO. Additionally, the defendant is aware she has the right to apply for a restraining order if she feels she is being harassed. Now, truthfully speaking, she applied. They denied her because they know the extensive history and they know she's lying. So Newark started to deny her. This is when she got the idea to start going to Middlesex and Union and other places to try to re-prosecute me when all of her cases are dismissed. So I'm being pursued through litigation abuse by the use of lower courts in municipal counties in different parts of New Jersey to keep bringing me before the court because this woman is mad about the decision of this judge and the fact that my social media content was protected by the First Amendment and did not violate any of her rights, as was told to her by this judge, as you can see. The nature of the relationship. On this factor, the court must determine whether the relation to today is one that would allow the defendant to exercise control over the victim. The parties were formerly in a dating relationship which ended 3 months before the entry of the TRO. They do not share any children. Currently, the parties live in different states as the plaintiff lives in New Jersey and the defendant lives in New York. However, due to the considerable litigation between the parties, they have frequently appeared before one another in court proceedings and have both made numerous allegations of harassment against each other. The court finds that this factor weighs against the defendant's application to dismiss. The number of times that the defendant has been convicted of attempt. Now, she's never been convicted of attempt because they won't charge her, not because she's not violating the order. Whether the defendant has a continuing involvement in drugs and alcohol, people as she did, they don't know because they don't test it. She damn sure ain't gonna tell them. Whether the defendant has been involved in other violent acts with other persons, people we probably don't know because she don't date nobody because her mother up her ass and everybody else just left her. Nobody got as close to her as I got. And this is why I'm receiving the harm I'm receiving from my ex-girlfriend because I got further than anybody else and she wants to destroy me. Whether the defendant has engaged in counseling. She claims she's going to counseling. She needs to go to a fucking shrink. Excuse my language. The age and health of the defendant. Whether the defendant is acting in good faith. Whether the victim is acting in good faith when opposing the victim's request. Now, this is important. Courts consider the good faith of the victim in opposing the defendant's request to dissolve the FRO. For example, in a divorce action, the court is mindful that sometimes one party abuses the act to gain advantage in the underlying matrimonial action. Here, based on the nature of the parties' relationship, the court finds that the plaintiff has no motive to gain by keeping the FRO in place outside the protection of the DV order. So basically, what the court says is, I have no motive to gain other than keeping the order active to keep her the hell away from me. The defendant alleges that the plaintiff is opposing the dissolution of the FRO in bad faith in order to abuse her through litigation and hinder her efforts to obtain employment. However, the defendant submitted no proof to substantiate this claim. The court notes that the plaintiff has adamantly testified as to his continued need for the protection of the court based on the tumultuous history between the parties. As established, the FRO was granted to the plaintiff against the defendant in 2022 on grounds of harassment and burglary based on the findings and facts and conclusions of law that were made at the time of trial. Given the short passage of time since the entry of the FRO and the reasonable fear of the victim, the court determines that the plaintiff is acting in good faith in opposing the defendant's motion. Therefore, the court finds that the factor weighs against the defendant's application to dismiss. Now, here's the truth, people. During this very hearing, and I can't show you because I can't show you the actual transcript, I testified that I would have been willing to drop the order if she left me alone. People, I wasn't trying to keep this order on this girl hold. I just wanted to chill. She keeps pursuing me. So, people, I'm never going to drop this order because I know she's going to keep coming after me. She's already proven it. Whether another jurisdiction has entered a restraining order against the victims. The parties have included. Okay, the parties have indicated that they are currently having temporary restraining orders against each other in Richmond County Family Court in the state of New York. As this decision, there have been 3 trial dates in this matter: May 21st, 2024, May 30th, 2024, and June 25th of 2024. The trial is still ongoing. At the last date is scheduled July 10th, 2024. So the court took that as a neutral factor. The court cannot find any relevant factors other than those addressed in this opinion as the defendant's basis for seeking the dismissal of the restraining order. Conclusion. For the reasons based on the review of the findings of the record, testimony taken at the hearing, and the legal authorities cited, the defendant's application to dissolve otherwise vacate the final restraining order entered on December 1st of 2002 is hereby denied. So for what everyone wants to see here, this is what happened with me. As you can see, I'm actually the plaintiff. This is my ex, she's the defendant. And what happened was that based on the things she did to me, The court denied her application and, basically left me as the victim. So I've shown you what litigation abuse looks like. You've read the decision of a court where you actually see what happens when someone continues to pursue you using the family court system and filing false and baseless petitions against you. It doesn't matter necessarily that a court will keep finding in your favor that you're telling the truth. Because the true problem is if law enforcement will utilize the protections granted to you in that order to provide you those protections. And if law enforcement chooses not to provide you, you are basically fucked. Excuse the language. So now how do we deal with this, people? Again, people, many of my broadcasts I've talked about something called 42 United States Code 1983. This is the only action you can use to hold law enforcement accountable when you have something like I just showed you, which is basically the decision of multiple judges that verify that your offender is stalking you. Yet, based on gender bias, racism, personal favoritism, discrimination, whatever it might be, these people just refuse not to grant you any protection as the actual victim. You First thing you have to do is you have to exhaust all administrative remedies. And what I mean by that, you contact internal affairs, um, you file complaints with the discrimination department of whatever your city or state is, you contact the attorney general, you do these things. You don't have to do it multiple times, but at least send a letter to everyone with as much evidence as you can and tell them this is what's going on. If no one answers you within 30 to 60 days, people, you do what you file is called a notice of claim, which is basically you guys are violating my civil rights. I want this, this, and this to happen by a certain deadline, or I'm going to sue you. Now, if they don't do it by that deadline, you file your civil action, you get your evidence together, and you go to war, people, because that's what it is. It's a war. It's a war against oppression. It's a war against gender bias. It's a war against racism. It's a war against discrimination, people. And if you choose to take a knee when people do shit like this to you, you're going to be a victim for the rest of your life. One day I woke up and I decided I wasn't going to be a victim anymore. I decided I wasn't going to let somebody continue to control my life just based on the fact that I was a black man who had no knowledge of the law and I had a past criminal record. Shit happens, people. We all make mistakes. Just because you made a mistake 20 years ago, it doesn't give someone the right to try to destroy your life and use that mistake from 20 years ago to create baseless allegations against you now. And anyone who does do that to you, excuse the expression I'm about to use, is a complete piece of shit, and they need to be handled and they need to be prosecuted and they should be held accountable by law enforcement in whatever city or state you're in. So, people, I think we're going on like an hour and 7 minutes. We did excellent tonight, people. I've showed you some real police reports, some real examples of litigation abuse, people. And again, people, I hope you can just utilize the information and try to do the best you can to get the situation off of you, people. We're going to do another broadcast in probably a couple of days where we provide you some tactics and things on how to establish the documentation, how to establish the document trail for your lawsuit. Because again, you have to exhaust administrative remedies. So what you want to do is you want to send the right communications to the right people with the right documents. So when you do get them in the civil courts for your 1983 action, you can show a federal judge, hey, listen, I did everything I can to mediate this. I contacted the prosecutor's office. I provided them with transcripts to show them what's going on. I contacted this cop. I provided him with text messages so going on. He didn't care. He arrested me anyway. If they have probable cause that can substantiate that you may be innocent of an allegation, the prosecutors legally have an obligation to honor to utilize that information, because it's about the interests of justice, not the personal influence or the personal goals of a prosecutor who may seek to get conviction to aggrandize themselves. It's not about that. So people um, document. That's what I can tell you. You keep documenting. You keep filing, you write those letters. And you watch my other videos and you figure out how you can file a 1983 lawsuit and hold these pieces of shit accountable. On behalf of Operation Rock and Clayton, we're going to get off because it's like an hour and 10 minutes. I didn't think to be on this long. I'm about 8.5 minutes over. Stay blessed. We'll be back on probably Saturday to talk about how you can write the prosecutor up, the judge, etc., like that. I'll show you some letters on how I basically structured and did it and what I included in it, and hopefully it'll help all of you out there. Because it takes a village, people. The more victims that come together, we share our experiences, we talk about the things that happen, the more we can do to stop these assholes from keep doing stuff like this to innocent people. So, on behalf of Justice, Operation Rock, and myself, thank you all for the time. Thank you all for staying with me as I detailed the litigation abuse that you may face, others may face, and provided you examples of what I faced in my life. It's always darkest before the dawn, people. So you got to stay strong. You got to stay positive, and never let them play you like you a sucker, because you're not. They're suckers, and you show them by standing on your ground, holding the 10 toes, standing on your deem, whatever it's called. You prove to them that you are a different caliber of person by beating them at their own game, not by lowering yourself to a level where they can prejudge you or make diminishing assertions about your personal character. You level up on the bastards and you show them that they made the wrong decision when they messed with you. So on behalf of justice, people, again, this is Clayton signing off. Good evening.